Counsel for the ANC has argued that there are only 3 grounds upon which the IEC can entertain appeals by parties aggrieved with the registration of a political party as contained in Section 16 of the Electoral Commissions Act. Now, the ANC argues that the IEC unlawfully registered the MK party after it supplemented its application. Arguing on the jurisdiction of the Electoral Court to hear the matter, Advocate Tsiriso Ramokgale says it can determine issues of legality in this matter. The ANC argues that there were procedural flaws in the way Deputy Chief Electoral Officer Mawetu Mozuri registered the MK party. It contends that the party was supposed to submit a new application and not supplement the original one rejected by Mozuri. MK party leader Jacob Zuma addressed supporters about the case earlier.
13 years ago, instead of moving forward, our very organization that was non-violent then, that we moved, and it was the one that was unbanned and became the government. In the 13 years of the time, it diverted, moved to a point where you had no hope that our lives would ever change. In other words, it was being killed by those who were leading it at the time. It was absolutely necessary to any revolutionary to remember that we once had an organization that had to rescue the ANC then. We now have to rescue our struggle now.
At the same time, ANC Secretary General Fikile Mbalula has addressed supporters outside court.
We have taken a decision to challenge this party, but not only that, we have been toiling since this party was registered, fighting for our logo, for our asset, for our own MK. To say that if Zuma wants to form a party, it is fine. He can call it Msholozi, he can call it Zuma, he can call it whatever he wants to call it. But we will never leave him to run away with MK. Because uMkhonto weSizwe belong to the African National Congress. uMkhonto weSizwe belong to the African National Congress and the people of South Africa. The party has taken a decision to take our asset and run with it. We took a decision to challenge him. We are challenging him in 2 levels in terms of this formation. You must understand, this is the beginning. Here today in the Electoral Court, we are challenging him in terms of deregistration of this party. That's the first leg. Next week, we challenge the patent, the ownership. Who owns uMkhonto? And then it is owned by ANC. So that is the second leg. It has been, should anything work against us, it will not be the end of the day. Should we register victory, it is equally good for the ANC. Comrades, we respect the rule of law. We are not afraid of anybody. We have seen them all and they failed. They started with Congress of the People. We defeated them. And today, and now, Jacob Zuma has done something that we wouldn't have expected from him. To form a political party against the African National Congress. Now, comrades, he has done it, and therefore he is here defending it as his party. And the African National Congress, we are here standing to say this is our property.
Canny Maphanga, SABC News Reporter, was there and joins us live now. Kenny, a lot being said outside court as well as inside court as the arguments continued. The ANC saying that it is not fighting with the Independent Electoral Commission, but the IEC also at the same point saying that the ANC did not object to the MK party in time, according to the law. Take us through some of the arguments that were playing out in court.
Well, good afternoon to you, Bongiwe, and to the viewers at home. You're a bit inaudible there, but judgment was reserved earlier today at the Electoral Court, where it heard the ANC's challenge of the registration of the uMkhonto weSizwe political party. Now, the ANC is contending that the central question here is a legality question on whether the Deputy Chief Electoral Officer can consider an application to register a political party on a supplemented application. Well, the ANC argued earlier in the Electoral Court this morning, contending that no, it cannot do that, arguing that this has implications for the current 2024 general elections and upcoming elections. That includes the local government elections, and they need this court to provide that clarity regarding this question, even though it is not explicit in legislation. However, it is the ANC's argument that once that August 2023 letter was written to uMkhonto weSizwe to say that their application could not be processed regarding their failure to meet some of those compliance issues, that the application itself was nullified at that point, and in order to proceed further, uMkhonto weSizwe would have needed to bring a fresh application. So in invalidating that registration, if they were successful, Bongiwe, that would have great implications for the MK party in the upcoming 2024 general elections. However, the IEC has a different interpretation of that, stating that there are internal mechanisms, review mechanisms, that is the objections, the appeal and review process within the commission itself before you could even head to the Electoral Court. They've stated that initially when uMkhonto weSizwe was registered, the ANC did go through an appeal process, and when they went through that appeal process within the commission, it was rejected. At that point, they abandoned that appeal. They didn't take it any further through those internal mechanisms. So the IEC is puzzled as to how the ANC ended up in the Electoral Court when they didn't use, or rather the words that were used by the IEC is circumvented the internal mechanisms that exist in the electoral system. Then, of course, the MK, which is the third respondent, says that there's no jurisdiction for the Electoral Court to even entertain this matter. And then, most importantly, almost aligning with the IEC's views, they're saying there isn't even a decision that you could even take to the Electoral Court to review, because they're saying in order for you to have a decision, you would have to go through those appeal processes first. And once the IEC comes to a conclusion, then you could approach the Electoral Court on review.
And Kenny, I suppose then, as you say, this takes it back to that issue of jurisdiction. And what then happens with internal dispute mechanisms? Do you then take those processes to court, as the MK party lawyers were saying that this is a matter that is looking at an internal process that should have been, but it's now coming to the court to mediate on what should have been an internal process. And that was one of the arguments that was put forward by the lawyers for the MK party.
Indeed, that's a critical argument, Bongiwe, because the electoral system has an act which prescribes the objections, the appeals, and the review mechanisms. And it is only once you've established a decision or a dispute that you can then go to the Electoral Court. But the ANC, to, I guess, supplement that argument, is saying that whenever a decision, or you are seeking rather legal clarity on something, so you're looking at the lawfulness of a public power or public function, then it automatically falls within the jurisdiction of a court. A court can hear something if they are trying to determine legal certainty on a public function.
All right, Kenny, thank you so much for that update. Do appreciate it there. That is Canny Maphanga, SABC News Reporter, who's been tracking this particular case for us.